Employees who engage in sexual activity at work can still claim sexual harassment. Podcast by attorney Deirdre Clegg. A central issue that many plaintiffs face in bringing claims for sexual harassment in the workplace is whether they were actually offended. More specifically, when a plaintiff has engaged in conduct at work that may be construed as sexual in nature, whether it be sending sexually explicit emails, viewing pornography at work on their workstation, or other similar conduct. The question that must be asked is whether such a person can assert a claim for sexual harassment and survive the defendant's challenge that such a person cannot claim any sexual comments or activities is unwelcome. The complaining party must actually be offended by the conduct at issue, according to the Ramsdell v. Western Massachusetts Bus Lines, Inc. case 415 Mass. 673 at page 677 through 678. To determine whether a claim of hostile environment harassment is made out, there is an objective and a subjective test. To be actionable, the harassing conduct must be work-related. The conduct complained of must be sufficiently severe or pervasive to interfere unreasonably with the work performance of a reasonable person in the plaintiff's situation, according to the Winters v. Adept Inc. case 76 Federal Supplement, 2nd edition, volume 89, page 95. In order to successfully demonstrate sexual harassment, a victim has the burden of proof. Massachusetts law recognizes two distinct categories of illegal conduct: quid pro harassment, where requests for sexual favors or acquiescence and sexual advances are made a condition of employment or as a basis of employment decisions, and the hostile work environment claim, where an abusive work environment is created by verbal or physical conduct of a sexual nature which unreasonably interferes with an individual's work performance, by creating an intimidating, hostile, humiliating, or sexually offensive work environment. To determine whether conduct is unwelcome, it is permissible to examine the victim's actions, according to the Meritor Savings Bank case. At the trial, the parties presented conflicting testimony about the existence of a sexual relationship between the plaintiff and the supervisor. While the question whether particular conduct was indeed unwelcome presented difficult problems of proof and turned largely on credibility issues, which were committed to the trier of fact, the district court in this case erroneously focused on the voluntariness of respondents' participation in the claimed sexual episodes. The correct inquiry was whether the plaintiff, by her own conduct, indicated that the alleged sexual advances were unwelcome, not whether her actual participation in sexual intercourse was voluntary. The court in Henson v. Dundee determined whether the conduct was unwelcomed by the sense that the employee did not solicit or incite it, and in the sense that the employee regarded the conduct as undesirable or offensive. The mere fact that a female employee participates in some workplace conduct that is sexual does not by itself prove that the conduct is welcome, and that she does not perceive her environment to be hostile, as would preclude a sexual harassment claim under Title VII or Massachusetts law. Nor does it suggest that the employee enjoyed or appeared to enjoy the campaign of harassment against her, according to the Horney v. Westfield Gauge Company case. That's a 2002 Massachusetts case. Evidence that sexually charged and abusive language in female employees' workplace, even if not gender-related, was used regularly by men towards women, together with evidence of sexual calendars, pictures, jokes, and posters in the workplace, presented a question for the jury regarding whether such conduct was gender-based as required to establish sexual harassment under Title VII and Massachusetts law. In determining whether sexually harassing conduct violates Mass law, courts may look to interpretations of Title VII, but are not bound by interpretations of Title VII in construing Massachusetts law prohibiting work environments pervaded by harassment or abuse. To establish sexual harassment claim under Massachusetts law, there must be showing that the work environment is subjectively offending to the plaintiff. Plaintiff must show that the employer's conduct was intentionally or in effect hostile, intimidating, or humiliating to plaintiff in a way which affected her work performance. In determining whether the work environment is hostile, significant out-of-work harassment may be considered. The foregoing podcast was brought to you by attorney Deirdre Clegg of the Law Offices of Goldstein and Clegg. For more information on sexual harassment or other employment law-related matters, contact attorney Deirdre Clegg at 617-974-7774 or online at www.goldsteinandclegglaw.com. That's Clegg with 2 G's.